on Monday, October 20th, about contracts with Stellantis. We are having some technical difficulties getting our Stellantis witness online, but as we try to work out the IT, I figure we'll just start with the opening statement. Just quickly, everyone's received the electronic copy and then paper copies. That paper copy has to be, they are numbered and have to be returned to the clerk at the end of the meeting. Thank you very much. We'll turn the floor over to Mr. Jennings for 5 minutes for an opening statement, and hopefully we'll have Stellantis on by the time your statement is up. The floor is yours, Mr. Jennings. Please go ahead.
Great. Thank you, Chair. And Chair, I do appreciate the opportunity to appear before you today to discuss matters related to the agreements between the Government of Canada and Stellantis pertaining to the Brampton Assembly Plant. The main point of interest of the committee appears to be how we have proposed to address your request for copies of the agreements, so I will focus my remarks on that issue specifically. Monsieur le Président, permettez-moi de commencer par reconnaître le...
Mr. Speaker, Mr. Chair, let me begin by acknowledging that this committee plays a vital role in shaping, informing, and advancing the effective functioning of government operations. The committee's oversight is essential to maintaining public trust and ensuring that our institutions are accountable. We are grateful for these efforts and respect the need to maintain transparency when providing information to the committee.
Transparency and the disclosure of information related to agreements between the government and third parties, it is also important to recognize the commercially confidential nature of some of the information contained in these agreements. The public release of commercially confidential information can cause significant damage. The automotive industry is highly competitive, and the information provided to governments when participating in government programming is shared with the understanding that it will be protected. This is equally the case in the aerospace sector, the artificial intelligence sector, and other knowledge-based sectors in the economy. This trust is critical to facilitating the sharing of information, for us to be able to do due diligence on the information, and a breakdown in that trust undermines the government's ability to position itself as a partner in future agreements. Ultimately, trust between parties is key to ensuring that the government funding drives innovation and competitiveness and is effective in growing the Canadian economy. Compte tenu de cette dynamique dans son ensemble,
given this overall dynamic, our recommended approach is to provide the committee with the contribution agreement for review with very limited redactions to protect commercially sensitive information. These redactions are less strict than those permitted under the Freedom of Information Act. We therefore also propose that the committee review them in camera.
This approach mirrors how we have addressed similar requests by parliamentary committees in the past. It facilitated the timely sharing of information with those committees. This approach also respects the agreements between Canada and Stellantis, one where we equally expect Stellantis to respect all of its terms. Given the sensitive nature of the documents and my desire to be as transparent as possible while also being compliant with the Department's contractual obligations, I would respectfully ask that the committee move in camera to ask any detailed, specific questions regarding the document provided.
I'm confident that Parliament will appreciate the commercially sensitive nature of certain information and will consider a solution that provides relevant information to support discussion and informed decision-making while protecting elements that could harm the Canadian economy.
Attraction and in turn jeopardize job creation and economic growth in Canada. Thank you, Chair. I look forward to the questions.
Wonderful. Thank you, Mr. Jennings. Colleagues, I apologize. I forgot, of course, Mr. Bidar and Ms. Gauthier are with us from the parliamentary law clerk. If you have any questions, they're here just to provide advice. But if you have any specific questions for them, please feel free to address to them directly. And it can come out of your usual 5 or 6 minute time. We'll start with Mr. Seaback for 6 minutes, please.
Great. So, in your statement, you just said that you're trying to redact, commercially sensitive information, which I understand.
Point of order, Chair?
What I do find.
I'm sorry, this is point of order. I'll stop the clock.
Was there any other opening remarks from any?
They haven't signed on yet. We're waiting for them to sign on.
Thank you, appreciate that.
IT issues. Sorry, go ahead, Mr. Subak.
Thank you very much. And I respect that you're trying to make sure that commercially sensitive information isn't available. What I have found when I've reviewed this agreement, and in fact reviewed other publicly available documents like the CIF agreement 810-819553, which is related to the agreements that we're talking about today, is that the redactions are not consistent. And so what I want to understand is, if you're saying it's commercially sensitive, that's the basis for the redactions, then why is there sort of a lack of consistency between the redactions and the documents? So, for example, in CIF agreement 810-819553, you redacted the costs of the various the funding agreement, but in CIF agreement, the one that we're talking about here, 813-816-251, the dollar amounts in fact aren't redacted, and the dollar amounts of the other agreement are in that document. Like amendment number 2 of CIF 816251 puts in the full amount of the $15 billion contribution. So it's not redacted in this document, but it's redacted in another. Can you explain that inconsistency?
The question. I don't have the other agreement that you're referring to with me. However, what I can say is that when we do get a request for documents for committees, in any case, we always approach the companies at the end of the day to make sure that we actually have a process in terms of understanding what they feel is commercially confidential and could be harmful to their competitive position. And we review that with the companies to make sure that in our assessment we also feel that there is some legitimacy to it being commercially confidential. In this case, as I've outlined in the letter to the committee, we feel that the information that is not included or that is redacted, maybe I should phrase it that way, is legitimately commercially confidential. So it's about IP strategies, it's about investments in R&D, investments in CapEx, which could actually give some sense to the competitors and give them some sense of what they're doing and could harm their competitive position. So it's a case-by-case basis. A company may feel over time that it no longer needs to be protected, and that may change. But as we do it on a case-by-case basis with each company.
Sure. Let's say I accept that explanation on CapEx and R&D and other things. But for example, in the document we're talking about today, 813 CIF agreement 813-816251, you've redacted the provincial funding envelopes. Like, how's that commercially sensitive? Like, you've got the federal CIF and then contributions from the provinces on page 19 and page 20. All of the provincial envelopes, funding envelopes, are redacted. How's that commercially sensitive? These are publicly available funding from the province.
Yeah. So my understanding in terms of what was redacted and not redacted is I think the amounts for all these funding envelopes were released. And what's
the amounts are there, but the actual programs where the monies are coming from are redacted. But these are public programs that would be available in estimates and other things. So, like, why would the programs be redacted? What's I don't understand. You said it's about being commercially sensitive. It seems to me it's inconsistent.
Yeah, please, Denis.
Okay. I can answer this. The redactions for the provincial breakdown of the contribution. It's not the title of the programs, but more about the locations of where that contribution will be dispersed. So which projects at which location will where the disbursement will happen.
So where the money's going is confidential. Is commercially sensitive. You determined to be commercially sensitive, confidential information.
That is what through consultation with the companies.
And is that what the company requested? They requested that be confidential.
Yeah,
Okay.
Yeah.
So is the process that you go through the company says we want all of these things redacted and you say yes? Or you say no, that's clearly not commercially sensitive and therefore we're not going to redact it. I guess what I'm asking is, do you have discretion internally to determine what was redacted for the committee, or was this just whatever Stellantis or which other company said, we consider this commercially sensitive, therefore it needs to be redacted?
I guess what I can answer is that, it's a back and forth discussion we have with companies on a case by case basis.
Okay.
And we play a challenge function in terms of what a company requests to be redacted or not. And we have always in the past, and including in this case, found a reasonable landing ground in terms of what's redacted and what's not redacted.
And how many people in your department have access to these documents to determine the redactions, and what are their levels in the department?
Well, I have, in this specific case, I have the people beside me that were involved in those discussions.
That's it. No one else in the department. No one else had access to these documents than the 4 people sitting here today?
Access to the contribution agreement?
Yeah, the contribution agreement, the unredacted contribution agreement to determine the
So
redactions.
A quick answer, please.
There would be officers within the program that were involved in the negotiation and the development of these documents who would see those documents, yes. So there is a team within the department that works on all of our contribution agreements. But those are treated commercially confidential, and we don't share that information outside of the department without the consent of the company.
That is our time. We'll go to Ms. Suds now for 6 minutes, please.
Thank you very much, Chair, and thanks to all of you for being here with us this morning. Obviously, an important opportunity to better understand the current situation, and unfortunately was hoping Stellantis would be here, but it seems that's not the case to date. So my question's directed to yourself. So perhaps just starting with, could you please describe the details of the Strategic Innovation Fund, as it's historically been called, and why it was created? What's its intended purpose?
Great. So thank you for that question. So I may get corrected on this, but I think it was created in 2017. And at the time previous to that, the funding by the Department of Industry, which was at the time, was really focused on very specific sectors, so the automotive and aerospace sectors in particular. And there was a perspective that we were losing out on some very interesting investments that were taking place in other sectors of the economy. So at the end of the day, there was a decision that was made to really have a fund that would be able to capture broader, attractive investments that Canada wants to have, including automotive and aerospace, but actually broadening out in terms of other sectors. And since that time, there's been, I don't have the exact number, but I think there's been 152 projects that have been undertaken under the SIF, and now what's called the Strategic Response Fund. There was just over $11 billion that federally that have been invested under that program, and that's for what we think is about just over $75 billion of economic activity in Canada based on those investments. The investments are pretty broad in terms of the sector. So I mentioned automotive and aerospace, but we also have biomanufacturing and life sciences has been a very important recipient, a sector, steel, aluminum, and heavy industries, which at this time, under the tariff threats from the U.S., is all the more important. Digital and emerging technologies, clean technology, critical minerals, artificial intelligence. So you really have an ability to capture the right investments. And the broader context is that other jurisdictions are also trying to create a policy space and a financial attractiveness space. We're trying to attract these same investments. So we are, at the end of the day, trying to attract those investments in Canada with a tremendous benefit. And by and large, provinces typically also support financially these investments. So at the end of the day, there's a recognition by both levels of government the importance of attracting these. Maybe just going back to just a point on redactions of documents, just to be clear as well, is that one of the reasons we also feel it's important to have some redactions is there are sometimes some elements in these agreements that we'd rather not have competing jurisdictions have full understanding of, so that we're able to leverage those investments as the best possible. So just as other jurisdictions do, we do think there's a moments in time when it's better not to release the full information from those agreements.
Point. And actually, just this morning, I was at Nokia with a SIF-related update on their project. So it certainly touches a lot of sectors. I'm wondering if you could explain for us the context of the Stellantis contract negotiations themselves, if that's not commercially sensitive to ask.
Good.
The question that Ms. Suds asked, I'm just double checking.
Yeah.
She's asking about contract negotiations. Is that what we're discussing right now?
Say the original motion, but that's fine.
Okay.
Go ahead.
Okay, so because I had not joined the department at the time of the negotiations, I'll just turn to the SIF team that was here. So I'll turn to Stephanie and Denis to be able to walk through, and Benoit may also have something to add on this.
And for clarity, I wasn't actually here at the
Okay.
time of the negotiation either, but I mean, I can talk maybe a little bit generally of how we approach as we enter into a negotiation for a contract through our kind of due diligence, and then how that process unfolds, if that is useful. I mean, I think when we are examining a project moving forward under the Strategic Response Fund, we undertake significant due diligence. We look at both the technical merits of the project, we look at the market assessment of the project, the financials of the project, and from that we develop a term sheet, which is the basis for our negotiation. Depending on the nature of the project, we're trying to secure different benefits. Typically, any term sheet, any agreement we would enter into is going to have benefits with regards to jobs. They're going to have benefits with regards to CapEx investment, R&D investment. In addition to jobs, there's usually co-ops, those types of investment. And then in the case of these where we're looking to secure mandates, there's also typically would be commitments with regards to those mandates as well. That is in a negotiation process with the company where we come to an agreed upon term sheet that then leads into the signing of the contribution agreement itself.
Oh, it's fine.
Madame Gaudreau, please.
I want to talk about something that happened in the past, something I also went through. It is perfectly legitimate to protect confidential information. We just received this document that has not been heavily redacted. So I'm wondering, this is taxpayer dollars. What about the jobs? What about the commitments? What will be the impact of the circumstances? There's a lot of information in here. And here's my question. And what I see has been redacted. See it in front of me. And I saw this with We Charity. We were with the clerk. No phones, no assistants, in camera. No notes were allowed to be taken. People voted for us so that we oversee their money. So we need to respect democracy. At the same time, we need to ensure that we do not jeopardize competitiveness even though Stellantis is a very, very important player in this world. So give me a reason why we cannot have the complete contract in a totally closed-off environment where only selected MPs are here and present. I'd like to thank you for your question. That's the balance we're trying to strike. When we talked to Stellantis, we wanted to ensure as much openness as possible with Parliament, ensuring accountability while protecting what needs to be protected. We did not talk with Stellantis about the possibility of having the complete contract for this committee, but we can ask them if ever FCA's witness joins, we can ask them today. But that's the balance we're trying to strike. We're not trying to hide anything. But we understand and we respect the fact that there are parts in the contract that are necessary for us to be able to do our work, and that investments made by tax dollars are also held accountable. That information allows us to ensure that there's due diligence with every contract. But I understand and I agree that there are parts of the contract that are not for public eyes that can be shared with parliamentary committees so they can review documents. And that's why the goal is to ensure that it's not public. I'm not sure if Stellantis is listening to us, but we're saying you're working with taxpayer dollars. Who's the boss? Is it democracy? Is it the government? Or is it the company? I was a businesswoman. I know about contracts. Contracts here is public dollars. So what are they scared of? If they don't want us to sit down and to properly review the contract in camera. As MPs, we are just ensuring that things are held accountable to democracy and that taxpayer dollars are respected. I'm really waiting for Stellantis' answer, because information disclosure can be variable. If I understand correctly, there won't be a lot of things that will be very surprising or shocking. So I just want to say, hear Stellantis say yes, we'll be in camera, and then no electronic devices. Just like, for example, the blackout before a budget. I already went through this before. Do you think we can do that? I cannot answer this. It's not something we directly discussed with Stellantis. In the past, when we requested the production of documents, there was always a certain amount of information redacted, and the information was shared behind closed doors. The information that I shared with this committee is just to ensure that we can look at it in camera. Those are part of the conditions. And here's my point of view. There has been a limited amount of information redacted and focused on what is, according to Stellantis, commercially sensitive information. Thank you very much.
We'll start. Mr. Patzer, please.
All right, thank you very much. So, Mr. Jennings, you're the Deputy Minister. Are you the one responsible for the redactions?
I'm not responsible for the redactions, sir.
So who was responsible for putting the black ink over all of the parts that were redacted? Who's responsible? Who's the one who crossed each line out?
So my team had direct discussions with Stellantis.
Sure, but who's the one that had the Sharpie marker in hand? And
Yeah, so Stellantis ultimately had to agree to what they were willing to have in the shared with this committee in closed doors versus what not. As the document that you have in front of you, the condition of that agreement what Stellantis had asked for is that it be shared in closed doors with this committee, and that is why the redactions were as minimal as they were.
okay, the motion from this committee asked for all the documents fully unredacted. So why did we receive redacted documents?
So if you wish, I can go through the reasons why we think it's important to protect some commercially confidential
Okay, but I'm
information.
just going to stop you quickly there because I think you've done that already with previous questions already, and in your opening remarks you already made reference to some of that. But what I am getting at is that there's 9 parliamentarians around this table. We agreed to a motion that called for unredacted documents. Ms. Goudreau did a good job of saying that in previous parliaments, there's been fully unredacted contracts put forward to this committee and possibly other committees, and done so in a manner that they could be viewed fully unredacted. How come we did not receive fully unredacted documents, much like other committees have before?
Okay, so my answer is first of all that we have a contractual obligation. So the contract clearly signs what we can release and not release, and it has to be agreed to with Stellantis. It was the first reason.
Okay, so which line in the contract stipulates that you have to have redacted contracts sent to parliamentarians?
I'll okay.
Like there's nowhere in here that said that you have the right to overstep Parliament. I didn't see that written in here. So where do you think that you have the power to disobey the will of Parliament?
It's clause 16.1, and just to be clear, I'm not trying to disobey the will of Parliament. What I'm trying to do is find a balanced way to make sure that you can do the scrutiny you wish to do and protect what's commercially confidential. And I proposed what was done in previous parliaments at both Indu Committee and Envy Committee, where we shared in closed doors very slightly redacted documents with those committees.
How many people within your department have seen this? Like, how many total people have seen this contract fully unredacted?
So I'll turn to my colleagues who may have a better estimate, but it's a handful. But I'm not sure if Stephanie or Denis would have a better number than that.
So, I mean, in addition to those of us at the table, we would have a team of, what, 2 or 3 people who would probably have
Plus if I a bit more.
maybe a couple more, because on the financial side.
How many? Sorry, I didn't quite hear you because you were turned towards him.
Yeah, no, I mean, I'm guessing on the size here, but I would say it's probably a team of between 4 and 6 people, in addition to those of us at the table.
In addition to
here.
you, so about 8 to 10 people. Okay. Mr. Bedard, I have a quick question for you and Ms. Gauthier. Clause 16.1 here, does that supersede Parliament, or does Parliament supersede 16.1?
So clause 16 in the contract is a typical confidentiality clause. Those clauses do not override the power of certain bodies, including the courts and Parliament, to compel the production of documents.
Thank you. Mr. Chair, how much time do I have?
30 seconds.
I'm good, thanks.
We'll go now. Welcome back, Mr. Berdisi.
Thank you, Chair.
5 minutes, please.
Bonjour. Je veux commencer juste.
Hello. I'd like to start by better understand contract negotiations. What kind of consultations internally took place for all clauses within the department? Well, I will ask the negotiation team to answer, but there is a lot of diligence. We start by understanding the market, as well as the technical and financial elements. I will ask the team to provide more details. We want to ensure that investments made by taxpayer dollars are properly invested. It is our opinion that risks need to be minimalized. But we understand that with every investment, there is risk. So maybe Stephanie can share a bit more.
I'll start and I'll turn to Denis. So in addition to the assessments I spoke about before, Denis can kind of talk a little bit more about who's involved in kind of the determination of a term sheet. I think it's also kind of important to indicate like a project of this size would also have required both Cabinet and Treasury Board approval before we move towards execution. So the general terms of what we would be negotiating and from the benefit agreements as well as from the funding levels would also have been approved at those levels before we moved ahead. Denis, but that's...
Yeah, maybe pour continuer.
To follow up, the team's work is focused on properly understand the project. So as the Deputy Minister said, to understand the risks. And in such a contract, we also need to know what will be the machinery and equipment used so we can pay for the activities. So there needs to be proper follow-ups, and we talk about that. The Deputy Minister said that around 150 projects have been negotiated. Each has their own contract, like the one we have here. And they're all different, right? Yes. Separate contracts for each project. Sometimes one company has several projects, but it's always different contracts for different projects. So more than risks, we also ensure that it benefits Canadians. So we have clauses to ensure that a certain number of jobs will be created and that there will be investments done in Canada.
Would each CIF agreement or special contribution agreement have a confidentiality clause like clause number 16?
Yes, that is typical for any, and like there's no sectors that we've negotiated with that have not insisted on having some protection, and that's really because they understand the need for us to have that information to do the due diligence, but they also worry that that would reveal commercial sensitive information if it would be public.
And are these clauses pretty much standard between CIFs and SCAs, or do they sometimes differ depending on the specific negotiation? We always start from a standard contribution agreement. So there's sometimes some very specific negotiations across sectors. So, for instance, the AI sector will have a lot more atypical clauses on IP, as an example. But by and large, they're typical, and this one in particular would be typical across almost all agreements. And prior to the provision of such a document to parliamentarians, what kind of consultations would happen internally? You mentioned Stellantis. Is there any other consultations? Would provinces be consulted since there's, in this case, a provincial contribution?
Yes. So we work with, in this case, Ontario was also a contributor to this project. So we do share information that's relevant so that we can actually, as we kind of proceed with the investment decision, it is of interest to sort of understand like what are the issues that they're raising, what are the risks they're seeing, as we think we can actually optimize how we finalize the agreements. But our agreements are signed or not shared with Ontario, and nor is Ontario shared with Canada. So we have a general discussion to make sure we understand each other's positions and perspectives, but we don't share the actual agreements.
And maybe at a certain level of...
I'm sorry, Mr. Radici, that is our time.
Okay.
And I'll go to Madame Gaudreau for 2.5, please.
Thank you, Mr. Chair. I have a question. Is Stellantis coming? Because, look, we're at a dead end.
We are still having IT issues with them. I'm not going to judge, but I'm not sensing a lot of desire for them to address the IT issues. But we've contacted them, we're waiting to hear back from them, and we'll keep at it.
look, they can come see us. But how is it that it takes an agreement with third parties to disclose a contract signed with public dollars and not all the numbers are provided? We understand the issue of commercial sensitive information. We just need Stellantis' green light, and then we can end the meeting, and then we schedule something that's unredacted, and then we can really get down to business. Because now we're taking 2 hours, and we all agree that it is our parliamentary privilege to see contracts completely. Now, in the negotiations, maybe there will be clauses that will not be there, because we want to honor those clauses. But at the end of the day, it's taxpayer dollars, so we don't have a choice. Mr. Speaker, Mr. Chair, I'm just waiting after Stellantis. I cannot accept the fact that this company has all the cards with the amount of money and the amount of jobs. Right now, we're talking about redacted information, but we want to ask questions. I have 30 seconds left, but look, I'm waiting for Stellantis here.
It's stupefying that they would not participate. We'll now go to Mrs. Jansen, please, for 5.
Is it on? I have to say, I am honestly shocked to hear that the department put Stellantis ahead of an order of Parliament. The idea that no one even raised the possibility of giving us the full contract is just, to me, unbelievable. And it looks like Stellantis was just, they walked over our request. And this is, it's an outrage, actually. And now we see that Stellantis can't even manage to fix an IT problem and appear here at committee to answer some of the redactions that they obviously told the department to make. So I have to ask, why would the department allow these redactions against the call of an order from this committee to allow us access to these unredacted documents?
Okay, thank you for the question. I will try to be brief and not repetitive, but just to go through a few things before. So I guess the first point, which I made in my opening remark, is that we have a contractual obligation that we signed between Canada and Stellantis. And as much as we want Stellantis to respect all those terms, we stand on more solid ground if Canada also respects all those terms. So there are terms within that contract that we think are very important at play at the moment that we want to make sure that Stellantis fully meets. Secondly, if you just maybe 1 minute, is that we also understand as we work with all these agreements and these companies that there is some commercially confidential information that we need to be able to do due diligence to go ahead and provide some investments. And we don't want to break that trust where essentially in future companies would be less likely and perhaps very constrained in terms of either sharing information that we need to do for due diligence or secondly not even approach us at all.
I'm sorry, my time is very limited.
Sorry.
So, what would be the justification for redacting the bottom of page notations in the amendment on Agreement 1? Like, how is that?
So I'm not sure which page you're talking about.
The bottom of page notations in Amendment Agreement 1. Can we hold while they look for that? Hold my time while they look for that? Amendment Agreement 1.
Okay. Sorry, so I actually do have an answer to that, which, sorry, I did not know before. So it's a privacy exemption for what's noted in this bottom of those pages.
So if those, like, there were other places where you've actually left in private emails. How is this suddenly now a privacy issue?
Well, we have emails of people that work at Stellantis.
Correct. Yes.
Which through the due diligence with Stellantis and back and forth, they feel comfortable having it out there.
But you're saying this is a privacy issue. Like, so this tiny little thing at the bottom of the corner, which looks like maybe it's, someone's initials. How can that be, personal information elsewhere has not been redacted. How is this suddenly a necessary redaction? Honestly, that Stellantis is not here, and that you're suggesting that this is all, you know, above board privacy, you know, personal privacy and who knows what is really quite shocking to me. This is an order that we made as a committee. All of us here said we needed these documents, and you're basically, you know, supporting Stellantis in redactions that look completely unnecessary.
I mean, just to clarify on that point is, you know, under the agreement that we did sign with Stellantis, we have to consult with Stellantis, as we would for any other company we're in agreement with, to make sure we agree on what we think is commercially confidential.
But you did admit that you didn't even ask them if they would allow the whole contract to be considered.
What we discussed, which we have done successfully in past parliamentary committees, is find a compromise in terms of being able to make sure the committee can review what it needs to do its due diligence.
And yet you took the entire schedule of work fully out. Like, you took the entire schedule of work fully out. It's like, it's an Accor accountability mechanism. You know, if you want to be transparent, how come that, why wouldn't you have asked them to include that?
So there is information in programs of work that actually can tip the hands to competitors in terms of what they're trying to produce.
Every word in that part? Every word in that section? Every word in that section is all completely private. Because that's how you've blacked it out. There's nothing left.
So as I said, in our discussions with Stellantis, that is what, in their assessment, needs to be protected.
So you do understand that redacting that schedule creates kind of the appearance of a deliberate cover-up?
We're in our discussions with Stellantis, we're comfortable with the redactions that they brought to this document. In our assessment, what's being released to this committee, which is supposed to be in camera, is more than would normally be released, and certainly well above what an ATEP request would release.
How much time do I have?
That is our time.
Okay.
We're going to go to Mr. Gasparo. I'm receiving somewhat positive news on the IT front, so I'll update you after Mr. Gasparo. The floor is yours, sir.
Thank you, Mr. Chair, and thank you to the members who are in person. I am incredibly annoyed that Stellantis has not been able to join us. You know, I understand they're working through the IT issues, but this is incredibly frustrating. And I just want to reiterate for the record, is at this point unacceptable. I do want to drill down just a little bit on, and I've spoken about this at committee before, in regards to the release of commercially sensitive information, and the strategic value of us being able to honor our commitments as a government, not only this current government, but future governments. So maybe we can just jump into it. How does our approach to the protection of proprietary and commercially sensitive information compare to other countries within the G7 more broadly? Do we have a line of sight there?
Yep. Thank you for the question. I'll just have Benoit, who would have a better, more comprehensive answer than I would on this.
Yeah, thank you for the question. I think the Deputy Minister mentioned at the beginning as well that there's not only sectoral, commercially sensitive information in terms of sectoral competition that are at play here, but there's also foreign direct investments and other countries that are also trying to attract the same kind of investments that we are trying to attract in Canada and sign contracts with those companies. And quite frankly, they would have a very similar approach than Canada in terms of protecting the commercially sensitive information in those contracts.
Okay. So this is if we're looking at this is a competitive advantage in terms of large, for lack of a better term, foreign direct investors into our country, in terms of investing capital in our country versus other jurisdictions around the world. Correct?
So I think the way to answer that was correct is that there are certainly many countries, and well, in this for different depends on the sector, but let's say for automotive, the U.S. and Canada would generally be speaking or be competing in terms of trying to attract those investments. There is an advantage ultimately to make sure that some terms of those contracts are not in the public domain, to actually tip our hands in terms of the approaches we take. Also, from a commercially confidential perspective, there are some, in different instances, there are some commitments that companies are making that they feel would be disadvantaged to them in terms of being in the public domain for either investment discussions they're having in the U.S. or for a competitive advantage with other automotive companies that they're competing against.
So basically what you're saying is the releasing of these contracts publicly would create an uneven playing field between us and some of our friends who are also competitors.
It certainly would be a risk that at the end of the day, the tools that we have would be less effective in terms of attracting investments if all of ours were public, and that were not the case with our competitors.
Can you name a single advanced economy where releasing confidential commercial contracts has led to more jobs or foreign direct investment, or both?
Thank you. I wouldn't be able to come up with an example of a country.
Correct. I sort of did the math on that one. So disclosing of commercially sensitive information, is it safe to assume would weaken Canada's ability to attract further large-scale investments from, to use your term, knowledge-based industries?
So it's fair to say that in our discussions always, and is that the element of protecting commercial information comes up in all our contract discussions with all these companies. At the end of the day, they recognize that we need that information to be able to do proper due diligence if we're able to make positive decisions in terms of supporting important investments that we want to attract to Canada. And they share it under the understanding that we protect that information and we seek their guidance when there is a request for information that such as this committee wants in terms of what we can actually redact or not redact in terms of being able to share that information for Parliament's review.
That is our time. We'll now go to Mr. Seaback for 5 minutes.
Chair. So CIF Agreement 810-819553, which is not the one we're talking about today, that was produced through an access to information request, and it's now in the public domain. It's on the CBC website in a PDF. I was able to print it off with limited redactions. But you're suggesting that this CIF Agreement 813-816251 can only be reviewed by parliamentarians in camera? The confidentiality, so we have to wait until someone makes an access to information request to see it? That's your argument? An access to information request trumps Parliament's right to review the documents?
So just to be clear, I've never suggested that.
But that's what you are suggesting. You're saying we can only review this document in camera with your redactions. However, the CBC obtained a copy of another CIF agreement, the same format. I'm looking at it. It's almost identical, clause by clause. It's now publicly available. Anyone in the entire world can review it. But you're saying this one is so special that we can't review it except in camera with your redactions. That's basically the argument you're making to Parliament right now. And I'm sorry, it's not making a lot of sense to me. Do we have to wait for an access to information request, or is Parliament supreme?
So maybe to answer the question as best I can, I'm here today to talk about this contract we have with Stellantis on the Brampton plant. And under the conditions of that contract that we signed, at the end of the day, we recognize there are elements that are commercially confidential that we have to do the best we can to protect it. And what we've recommended to this committee is an approach that we've done in past parliaments, where at the end of the day, we found a compromise in essence of being able to protect this information that the company feels is important to protect to be able for their competitive position, while at the same time allowing the scrutiny that this committee wants.
But if it's subject to the Access to Information Act, which it is, as you pointed out, you pointed us to Section 16, it's 16.1, and a news organization was able to get the entire document through an Access to Information request and publish it online, you're not protecting anything commercially sensitive. You're just delaying parliamentarians from being able to review it. We just have to wait until someone does an Access to Information request. Then we can view it publicly and discuss it. How does that make any sense?
So I can't speak to the other contract. What I can speak to is this contract. And for
so
this,
you know nothing about the other CIF agreement that was signed at about the same time?
Well, what I can't speak to is when and how the what's in the public domain got into the public domain. What I can say is that the information that's redacted in this document.
But you're saying we can't even publicly discuss it. You're saying this document has to be discussed in camera. Or I guess we can file an Access to Information request and then we can have it in the public domain like the other one. It seems to me like you're saying someone who makes an Access to Information request has more authority to review a document than the Parliament of Canada. And I find that deeply troubling.
Okay. So I'm not suggesting that in any way. If there were an Access to Information request on this contract, it would be subject to the Act and exemptions and redactions that would take place related to it.
So
my interpretation of the Access to Information Act is that what is commercially confidential would remain commercially confidential through that process.
Okay, but not the entire document is commercially confidential, because even this document you've given us limited access to, you've only redacted certain things that you claim are commercially confidential. Therefore, the entire document isn't commercially confidential by your own analysis.
Okay. So just to be clear, when I shared this document with this committee, it was under the understanding, which at the end of the day is not ultimately what happened, but is that we would have a discussion, and that document would only be shared in closed doors.
Well, the document hasn't been shared.
And the reason why we did that
hasn't been shared outside of this room. No one's referencing specific sections of the contract, in fact, except you. You mentioned Section 16.1 about confidentiality, but you seem to be dancing around this. If an Access to Information request can produce the entire document with redactions that are commercially confidential, but you're saying this contract cannot be reviewed by Parliament except in camera, meaning no one gets to see it, then you're saying that Access to Information has more authority than Parliament to review documents.
So I'm actually trying to say.
Sorry, very brief answer, Mr. Jennings.
Sorry.
Brief answer, please.
Okay, so I'm not suggesting that. We're actually trying to find and proposing a way for this committee to be able to review the document and have a discussion of the document so that it can do its due diligence related to it.
Thanks. We'll go to Ms. Khalid, please.
Sorry, I believe it's Tim, Mr. Watson.
Oh.
Merci, Monsieur le Président. Merci.
Thank you for allowing me to ask questions, Mr. Chair. I have a question for you, Mr. Jennings. Our colleague talked about access to information and the document that we're looking at today. I want to know, will the document produced through the ATIP process have the same information as what we have today? My opinion, and the opinion of my team, is that if there is an ATIP request, redactions in this document will be there, and there will be more redactions. That's why we have requested an in-camera meeting. That's how we talked. That's our solution with Stellantis as well. The only way for us to convince them to share so much was by telling them that we would share information in camera. Thank you. I want to also say that I'm frustrated with Stellantis that is not here today. That's incredulous. I understand that there are technological issues, but I think that is unacceptable. Mr. Jennings. You talked about an environment where we can look at the document in camera, so there will be less redacted information. You said that already happened at Indu. Can you explain us the procedure to see the document in camera? Just to be clear on my past comment, when it comes to other committees with whom we shared documents in camera, there were redactions. But there were a minimal amount of them so that committees can review them as much as possible. But in the examples that I gave, we never gave a document that was completely unredacted. I know you did not talk to Stellantis, but do you believe that Stellantis would agree to produce documents that are minimally redacted in that context? I think that they think that this is already a minimally redacted document. If the committee wants more information, then we'll need to talk with Stellantis. And I don't mind having another discussion after this meeting to see if they are open to sharing a completely unredacted document if it is done in camera. I think that goal of the committee is to gather as much information as possible on a public contract with public dollars, while understanding that governments also need to protect commercially sensitive information. I don't understand how disclosing everything will jeopardize our country's competitiveness. So I think my request is reasonable. I would like to once again reiterate, and I'm a new MP, I don't understand why Stellantis is not here right now. It is their responsibility to provide us with the relevant information. So I just want to reiterate the fact that I am deeply frustrated with Stellantis, and they should be here with us today. So you're essentially saying that you're not sure if Stellantis is ready to share a completely unredacted document, even in camera. Is that it? I don't know. Just to go back on an important point. We want Stellantis to respect all the terms and conditions of this agreement. So breaching the contract is something that I am not ready to do easily. So I think that we need to talk with Stellantis to see if they're ready to disclose more information. This is, according to us, already a document that has only a minimum amount of redactions. I do believe we should not breach a contract with a business that is valued at billions of dollars. We need to keep our competitive edge with other countries that may also be competing for these kind of contracts. So thank you for your answer.
Okay.
Can you give us examples of types of information that may be considered commercially sensitive? Yes. Here's an example. If there is investment to develop a new product that will be commercialized, usually that product cannot be disclosed before the product is public. So we want to protect that as best as possible. And redacting won't be necessary once the product will be commercially launched. But before that, we want to ensure that it is properly protected.
OGGO, please, for 2.5.
I'm speechless, Mr. Chair. I feel that there's disdain here. I know that Stellantis is listening in right now. You shall see what's in the contract. But between you and me, Mr. Chair, a company of that size knows that they have disclosure responsibilities, especially when Parliament asks for it. And we will do so in camera. I have a question for you, Mr. Clerk. Because, once again, I'm absolutely speechless. Mr. Bédard. What will it take so that we can ensure that the company comes and meets us in an environment that will protect confidential information? What do we need to do to make sure that that happens? Because when you build EVs, when you are on the cutting edge of technology, it's unbelievable that they have internet issues. We have been waiting for an hour for them to show up. So what does it take for them to show up? From the technical perspective, I think that the solution is being found. If the committee is faced with a refusal to testify, we can always summon them, and if that is not respected, we can refer to the House, and that can be seen as a breach of privilege. So in closing, I think that there is this tug of war. And this shows me that Stellantis wants to show that it is better than what allowed it to be what it is today. I'm thinking about taxpayer dollars. And we will respect private information. So Stellantis, if you're listening to me, we're waiting for you. If not, we will summon you.
Sure, please.
Thank you very much, Mr. Chair. So, Mr. Jennings, you talked about in order to do these redactions, you consulted with your department, you consulted with Stellantis. Did you consult with the minister on these redactions?
Thank you for the question. No, we did not interact with the minister or the minister's office related to the redactions.
So you're given free rein, and the minister has no oversight to what the department does?
I'm just stating the process we followed for the redactions for this contract. We were satisfied that the spirit of what was requested was followed by Stellantis, as has been the case in previous cases where we've had interactions with companies related to redactions. We felt that the company was open to a very small amount of redactions and sharing the documents in closed doors meetings.
Well, I hope you leave today with the impression that members of Parliament are not satisfied with the state of the documents as they are. We requested unredacted documents, and as has been outlined before, there is a process that has been established previously on how we could do that, and this is not being followed. Has the minister seen the fully unredacted contract?
I certainly would, if she has, it wouldn't have been through my office, so my sense is no. I have actually not seen the fully unredacted version myself.
Really? Okay. As far as departments go, I mean, I find it a little bit rich that only maybe 4 or 6 other people other than, I mean, because you said everybody at the table had seen it earlier, now you're saying you haven't. But to say that there's only been 4, maybe 6 other people that have seen this contract, I mean, has Privy Council, has PCO seen this contract unredacted?
So my sense is no, they would not have seen it. We really treat these documents with a lot of care. So at the end of the day, it's on a need-to-know basis to be able to see the full contract. I've not needed to know this contract. I wasn't negotiated while I was deputy, so I've not needed to see the documents. Had it been negotiated when I was deputy, then I would have seen the document.
Okay, so the previous deputy minister saw the contract.
Well, I'm assuming that. I don't know that for a fact.
Okay, what about legal? Like, obviously, there's some legal folks that would have to see it. Is there a legal department that would have seen this?
So that is a good question. I'll turn it to my team just to say how typically legal is involved with looking at contracts, if that's okay with you.
Briefly, please.
So I think as was said earlier, we have a standard contract that is developed with legal. Legal gets involved in discussions around specific clauses if there is debate and negotiation and we're trying to land in a position and there's legal risk. But typically, would they review the full thing, Denis, before? I don't think they do. They would see clauses if
Really?
they're outside the standard. Because we have a template agreement where our clauses are the same. And then what we typically negotiate with the company are the specifics with regards to their statement of work, their benefit commitments, and the like. Those are more about the project and what we're trying, and they're less about the legal commitments.
Okay, so you're telling me the legal team for a $15 billion contract doesn't see the entire contract?
They would be pulled in where clauses are deviating from what we would typically negotiate, would be my understanding. Denis, is there anything you'd add to that?
Yeah, I think there are obviously lots of clauses on those that they have seen, so they would have a real sense of the whole contract.
Okay, so you're telling me though that like somebody from legal, there should be more than I would assume that there's somebody that's overseeing the entirety of this contract. You're telling me that it's a piecemeal approach to how we're dealing with these contracts. And how come legal hasn't seen the entire contract?
We enter into a negotiation. We have a term sheet that outlines the terms for which how we're going to approach the negotiation. And we have a standard template for our contribution agreements that has been vetted by legal. We then enter into negotiations. That negotiation is led under my team. Under my team, I have an operation group, which is led by Denis. I have a financial group that is led by another DG. And then our industry sector, Benoit is here today, is involved from a market perspective. As well as then legal will be pulled in if there is disputes with regards to specific clauses that deviate from our template. We keep a team small with what comes to the negotiation of these. And when we go forward for approvals, whether that is to cabinet or to treasury board, or if it's going up for ministerial approval to execute through a project summary form, we summarize the key points of that agreement, what is being achieved, the financial aspects of that, the benefit commitments, so that everyone has a clear view of what is being agreed to.
That's more than 4 people.
Thanks. We'll now go to Ms. Khalid for 5 minutes, please. And just an update, we are still trying with Stellantis.
Thank you very much, Mr. Chair, and thank you to our officials for being here today. I'll start with asking, what's the relationship between the minister, the minister's office, and the department in terms of negotiating contracts and then redacting them when there's requests for them to be made public?
Yeah. So, the answer depends on at what point in time we're at. Obviously, if we're negotiating a contract and ultimately we do need approval from the minister to kind of proceed. So in those cases, a minister will have seen the terms of what the contract has been negotiated to be able to sign off. And if the contracts are over a certain amount, we have to go through cabinet and treasury board to be able to get those approvals. Post fact, so in this case is what we're talking about. So we have a sort of a new minister that was not involved in the negotiations. So there's no need for her to see the entire contract. So we brief her on as needed in terms of some elements of the contract to be able to satisfy the questions that she has related to it. And she's asked many questions recently on Stellantis, given that the decision for them to move the Jeep Compass production from what was planned for Brampton into a facility in the U.S. But we don't interact with her or her office in terms of what redactions take place. It is a contract between ISED and the company. So at the end of the day, the contractual obligation is to the department, and we make sure that we respect that by asking the company what are the redactions that they be willing to live with that's commercially confidential to be able to share with the committee. We did, in those discussions, encourage the company to be as open as possible, given the requests to make sure that this committee has as much as possible. And they've agreed to do that under the condition that the discussions would take place in closed doors in terms of what is the content of what was shared with this committee.
I appreciate that. I am actually really devastated that Stellantis has made this move, because this is my constituents and my city and my region whose jobs are directly impacted. So, and then for Stellantis' failure to appear today, it just adds fuel to my fire, to stand up for my constituents. But for yourselves as a department, can you explain the difficult situation that you're in as a department, where you're trying to protect Canada's ability to negotiate contracts, to bring in investments, while also making sure that our taxpayer dollars are spent effectively and are actually used for what we need them to be used for?
Yeah, so I mean, that's, in some ways, that's the crux of the issue, is at the end, like, we need to have full information, including commercially confidential, to be able to come to an agreement. Otherwise, we're not effectively deploying the money that has been asked to do. So that's why we take the approach of making sure that for the due diligence phase, and in terms of some of the commitments that are in the actual contract, we need to have commercially confidential elements of it to be able to have the contract we have with those companies be as effective as possible. And that, just to be clear, Stellantis, it's all the companies, 152 plus companies that we have agreements with, that essentially agree to share commercially confidential information with us so we can do our work. What they also insist on, which are clauses that are standard in these agreements, is that we protect what is commercially confidential so that their competitive position is not ultimately broken and compromised by participating in a program that is supporting innovation and risk-taking by the private sector.
Thank you.
Okay.
I appreciate that. So I'll ask, have there been any freedom of informations put in for any of the documents that we're discussing today?
Sorry, I missed the beginning of that sentence.
Have there been any FOIs put in for the documents that we're discussing today?
Sorry, I'm just not familiar with that term.
Freedom of information or access to information, sorry.
Has there been? Okay, no, I was not aware of, and my team is telling me there's not been an access to information request related to this document.
Okay, thank you. So I will ask you then, how can companies trust government, and how can workers trust government? How can taxpayers trust government? Because while you're on the front lines of bringing all of these three stakeholders together, what do you think are next steps to take when we're dealing with negotiations like this, when we're trying to make sure that we're attracting good investment into Canada, and to make sure that people aren't taking our hard-earned taxpayer dollars and then moving off to other parts of the world?
I'm afraid we're well past our time, but could you offer a short response if possible?
Sure. I mean, I guess as short as possible would be like trust. Trust is at the core of these agreements. So at the end of the day, the only way we can actually come to an agreement is that we both trust that both parties, the government and in this case Stellantis, trust each other, that we'll be respecting all the terms of the agreement. And for us, it's fundamental. We're at a point in time where we're expecting Stellantis to respect all the terms in those agreements, and they're expecting us to also respect those terms, which include not divulging information that's commercially confidential.
Thanks. We'll now go to Mr. Ho. Welcome to OGGO. Mr. Ho, the floor is yours for 5 minutes.
Thank you, Mr. Chair. So I have trouble just understanding why there are so many redactions in this agreement that taxpayers, Canadian taxpayers and Canadian public are interested in. So I'm just going to pick out a few that stands out to me. So in section 6.35, it mentions the Stellantis' commitments, which are legally binding obligations to make research and development investments into facilities in Canada. But the dollar amounts of these R&D commitments are redacted. Why is that? I mean, Canadian taxpayers are expecting value for their investment, that if they're going to if taxpayer funds are being used to fund this multi-billion-dollar so-called investment, the Liberals like to call it an investment, that there will be some return on that investment. So why would such an important figure be redacted?
Okay, so I'm going to answer with a broad statement just related to what I asked in my opening statement, which I'm happy to discuss, is that we do not discuss the actual terms of the contract in a public setting. The agreement we've had with Stellantis is that we would share the redacted version and have discussions of it in a closed-door session.
But I'm asking why these specific terms are redacted. I'm not talking about the terms themselves. Why are these dollar amounts? There's some of the other dollar amounts aren't redacted. I mean, the crux of this is that Canadian taxpayers are trying to figure out whether Stellantis are going to create those jobs, whether they're going to make those capital expenditure investments, whether they're going to do the R&D here in Canada. And you redacted some of the most important information, and you left in all the, boilerplate legal clause, like the confidentiality agreement, the governing law clause, but the most important information was redacted. I mean, who are we trying to protect here?
Okay, so I'm not going to comment specifically on anything within the contract that was shared under a condition that we talk about it in closed doors. However, I can say that in our discussions with Stellantis, they outlined to us for every redaction of what they felt, why it felt to be necessary to be protected commercially, and we were comfortable with the redactions that they proposed.
So the interest of Stellantis comes first before the Canadian public. Is that what you're saying?
No, I'm not saying that at all, actually. I'm actually saying that, Stellantis has shown an openness to sharing more information with this committee than would be publicly available to make sure that there is a full discussion and scrutiny on the contract.
Well, we talked about parliamentary privilege earlier this meeting, and we know that these compelling disclosure of this document is exempt from an unredacted state is exempt from the confidentiality provision in the agreement. So clearly, these redactions are done voluntarily between department officials. Is that right?
Well, under the terms of the agreement, Canada must discuss. In this case, our department, ISED, has to discuss with Stellantis. Any disclosure of documents and what redactions they feel they have. Otherwise, we're breaking the contract, which requires us to treat information confidentially unless the company is willing to share it.
So you mentioned. So what is so commercially sensitive about these documents? I mean, the clauses. We're not talking about spreadsheets with names of employees and all that. We're just talking about clauses in the overarching agreement. So I just fail to see what's so commercially sensitive about this. Like, it's not industrial designs or schematics and trade secrets that we're disclosing. It's just a text of an agreement. So it's just the most basic outline of the relationship between the government and this multi-billion-dollar company. And don't you think that taxpayers should have some closure in seeing what's in this document?
Yeah. I can answer that question, but I'd say the best authority to talk about the justification of what is commercially confidential proposed and the redactions proposed would actually be Stellantis. That's who we consulted under the terms of the agreement that we signed, is for them to identify for us what they felt was commercially confidential. So I think that would be the best to ask Stellantis that question.
That you discussed with Stellantis, or your department discussed with Stellantis previously, to determine which issues were considered commercially sensitive, too sensitive for Canadians to understand and to be made aware of. So, how do you reconcile that?
I have to interrupt. That is our time.
Thank you.
But I think there's time for a couple more interventions after. We're going to Mr. Gasparo now, please.
Thank you, Chair. Mr. Jennings, can we go back to your letter to the committee, and can you just remind us again? And I apologize that in your letter to the committee, you talk about the protocols of having an in-camera session, and you say that to review the documents, I think there's three provisions: supervision of the committee clerk, no personal electronic or recording devices, no notes be taken out of the room. Is there precedent for this?
So that is what I think I've answered before, but let me just go through in a bit more detail. So there is precedence for it, which is actually why I proposed it. I felt it was a sort of a nice balance between the need for parliamentary committees to actually do the scrutiny and the work that they need to do, while balancing the commercial interests of the companies that sign agreements with Canada and respect the contractual obligations. So just to give you three examples, and I'll be quick enough on this, is a Standing Committee on Industry and Technology in 2023 and 2024 agreed to this such an arrangement. So in those cases, in one case it was with Volkswagen, and the other case it was with Nexstar, where we had an agreement that the redacted versions would be shared in closed doors, and essentially there'd be no recording devices available. And the third case that I'm aware of is the Environment and Sustainability Development, so the Standing Committee on Environment and Sustainable Development. And in that case, it was one stream of programming under the SIF, so NZA1, I believe, where we took the same approach. So what I was recommending to this committee, which is why I wrote it, is that we take that approach. We actually have the documents shared in that fashion, and have witnesses, including Stellantis and ourselves and whoever else you feel necessary, to have a discussion in that setting to be able to maybe fully understand the terms of the contract and why things were redacted and not, so that you can actually properly do the scrutiny that you need to do as a parliamentary committee.
And I'm going to go back just quickly to the competitive advantage line of questioning that I had earlier, and thank you for going into some more detail on your previous question. Do you think the United States or Mexico, who are aggressively competing for these very same foreign direct investment dollars and for these very same jobs, would ever expose contracts like this publicly? And if so, under what circumstances?
Okay, so I would say that by and large, it would not be practice to share that type of information. And I can tell you that in some cases, actually, as a department, we try to understand what are other jurisdictions doing so that we can be more competitive. And the more information we can garner of what other jurisdictions are doing, the better position we are to try to attract those investments. So in some ways, it is a comparative advantage to actually have less information in the public domain than in other jurisdictions to actually properly attract an investment. The other thing I'd say, which is important, is that it's also important in us leveraging the most out of each of the investments. So if we were public with all of our agreements, we have less leverage to negotiate the best deals with companies. So at the end of the day, we do think it's important to be in the public domain with what we need to, but keeping the commercially confidential stuff out of the public domain so we can leverage the best return as possible in terms of the agreements. And as I mentioned to this committee earlier, we feel relatively good in terms of what we've leveraged from the SIF and now the SRF. So we have just over $11 billion has managed to leverage over $75 billion of investments in Canada across a whole range of sectors and across all regions of the country.
How much time do I have, Chair?
20 seconds.
Okay, I'll be very quick. Do you think the contract as is provides enough flexibility for Stellantis and other large investors into our country to find a new model for the Brampton plant? Because ultimately it comes back to the workers.
The contract includes clauses to be able to work with Stellantis to ensure that they meet all the terms of the agreement, which includes having a production in Brampton.
Thanks. We'll go to Madame Gaudreau, please, for 2.5.
Donc,
So, a question for you, Mr. Chair. What is happening with Stellantis and their internet connection?
We are still working on it. They still don't have they still do not have access, I'm afraid. No. If you have a point of order, but.
A point of order, Chair. Given the late hour, I don't think that we should continue trying. I don't think that it would be fair to all of us if the company appears at the last minute and then they've checked off their box. I think members do have questions, so I think we should.
I respect that. I think we'll keep trying, but I'm getting a sense that that we will find another time for them to appear. But they could appear in 1 minute, or it could be 25 minutes. But I think we'll just play it by ear for the next round. We'll start from the very fresh for 2.5 minutes. Thanks.
Oui, Monsieur le Président, en effet.
Mr. Chair, I still give them one last chance, but if they cannot provide enough answers due to the limited amount of time, then I think we should all agree that before ending the meeting, we will table a motion. So I want to talk about prevention. I understand that you were not there when the contract was written. Did you talk to your predecessor, the person who wrote this contract? I did not talk about this contract with my predecessor. But there are things in my department, and that if people change jobs, we ensure that records are not lost so that we can keep properly manage the contract. Stephanie's team and the people who renegotiated this contract, if they leave the job, they will share the necessary information with their successors. So, about the clauses that brought us here today, I think that you will put forward recommendations to ensure that this does not happen again, meaning that such a player will not have the long end of the stick because they clearly just look down on us. So I think that unless they want to hide something, but I'm not going there. But it is extremely important that businesses understand that they are not the one driving the bus. They receive huge amounts of money. So when you have new wording in future clauses, I want to ensure that you won't have to come back here again. Not that I don't like seeing you here, but I understand that we all have, that time is very precious for all of us.
Mrs. Jansen, and then Ms. Khalid.
Okay, thank you very much. I don't know if maybe I need to ask Mr. Bedard, but if it would appear that Stellantis is breaking the agreement by moving to the U.S., do they have any right to continue to demand the commercially confidential part of the agreement, or would it suggest, if they can move, that it's within their rights to leave based on the contract?
We look at the contract in terms of potential confidentiality of information, not in terms of the clauses. So I'm not in a position to answer to your question.
Okay. Maybe I'll ask Stephanie. It appears that Stellantis is breaking the agreement by moving to the U.S. And so would they continue to have the right to demand commercial confidentiality?
So in the agreement, there is a resolution process. So currently, and as I think our minister indicated in Nindu on October 3rd or 4th?
November 3rd.
November 3rd. We have entered into the resolution process with the company to determine whether or not there is a breach.
Okay. So I have another question then. We've admitted that the department is using boilerplate contracts and that they don't bring legal counsel to the table when you're actually in the business of negotiating a contract like a $15 billion contract, something I can't imagine happening in the private sector. Now, Stellantis is moving their plant to the U.S. It would appear that a boilerplate contract that you're using isn't really equipped to ensure things like a jobs guarantee, clawbacks, and so forth. Would you agree?
So I did not say we use a boilerplate. I said we have a template.
I believe that Mr. Jennings did, perhaps.
We have a template agreement, and then there are template agreements on that we then negotiate very significant portions of these agreements, including the benefit agreements, including the financial provisions, on a case-by-case basis.
So you do have lawyers in the room.
So the benefits agreements in this agreement would have been negotiated specifically with Stellantis to reflect the project itself.
Right, but
those
so that
are
means
not boilerplate.
So you would have a lawyer in the room when you're speaking with Stellantis on this particular thing. You would have a lawyer sitting beside you, which would be normal for any other private company to have lawyers in the room when you're making these negotiations, because they're going to see those details.
We do not have legal sitting in with us in every conversation we have with the company during the negotiation and as we work towards the final agreement, no.
Okay, so we've clearly established from the law clerk, thank you very much, that this is within our parliamentarian rights to see these unredacted documents. And yet, somehow you believe that 9 of us MPs can't see those unredacted documents in a closed-door meeting. Like, we're not asking to put this out into the public. Are you concerned at all that people watching this may see this as a cover-up from the government?
Just to be clear, once again, what I've done is suggested a past practice, which I think carefully balanced the needs of a parliamentary committee with the commercially confidentiality clauses that we signed with companies. But I suggested to this committee is we follow the same process, which is essentially to make sure that we work with the company in terms of understanding what should be redacted in terms of a document, and that we share that in closed doors. In past parliamentary committees, they've agreed to that process. This committee may not, but that is what the past practice of finding the right balance.
So, however, based on the redactions, I just don't see how we as parliamentarians can determine whether or not we have any leverage as government, you know, in regard to timelines or job guarantees or anything like that. Like, I just don't. I don't see how we have that the way you guys have done these redactions.
So the work we did with Stellantis was about trying to minimize how many things were redacted. So you mentioned jobs just now, so that has not been redacted. The covenants related to closures was not redacted. These are elements that you could argue are commercially confidential, but the company is willing to share it with this committee in a spirit of openness.
However, the wording that's used, and I have no idea what I'm all allowed to say, but the wording that used is so airy-fairy out there. It can be decided in Stellantis's good pretty much every time, based on what I've read.
Sorry, I'm not
The
quite clear
wording,
on the question.
in this contract, which you guys have, which again I don't know whether I'm not allowed to use any of the wording, is so general. It's just so easy for Stellantis to be able to argue for themselves.
Well, it certainly respects what we think with each company is they're looking to protect what's commercially confidential.
I'm not even talking about the commercially confidential. I'm talking about job guarantees.
Sorry, I have to interrupt. That is our time. Ms. Khalid, please survive.
Thank you very much, Mr. Chair. Thank you guys again for being here today. I have one question. So I served on the Winnipeg Labs committee where we looked over confidential documents to see whether the redactions were necessary or not. There were a lot of documents for sure. Now, a lot of that dealt with national security and intelligence issues. In your instance, can you walk us through what are the considerations that your department would take in the redactions that are proposed in these documents?
Yeah, so I mean, to clarify for this committee, is that the redactions were following discussions with Stellantis in this case.
In past discussions, there were different companies that we've had discussions in terms of redactions, and it's what they feel is commercially confidential based on the current situation. So as I gave an example earlier, if they're going to launch a new car product, as an example, they want to protect that information until that project is launched. So we want to protect that information. So the only people that would be best in understanding what should be commercially confidential until when, it would be the company. So that's who we interact with to make sure that it is protected as long as we can. In terms of the suggestion to have an approach which is perhaps similar to what you had, but in a different context, a different committee, I mean, that is what I think would be a constructive way to potentially spend time, is really about having to look at what's redacted in those documents, have Stellantis at the table, which are the ones who recommended those redactions, to make sure that there's full accountability for this committee in understanding why the redactions were made and whether, in your judgment as a committee, you feel that those are commercially confidential or not. We have our own judgment as a department, but you have to make your own judgment as a committee whether you agree with that or not. We're pretty confident that what is being redacted is commercially confidential, and we feel confident that they've gone, beyond what would normally be the case as an ATIP for sure, in terms of releasing as much information as they can.
Thank you for that. So, and I know that all members in this committee had really wanted to ask a lot of these questions to the company in question as well. So, Mr. Chair, I do want to move a motion at this point that representatives from Stellantis, Inc. appear before the committee for at least 1 hour to discuss the motion for the production of papers adopted on Monday, October 20th, 2025, about contracts with Stellantis, and if they do not appear on or before December 4th, that a summons be issued for them to testify before this committee for at least 1 hour on December 9th.
I suspect that there were similar motions coming from the other two parties, so that's glad that you put it out there. I was actually going to suggest very similar that we don't have a lot of open time, but I thought we could fit 1 hour before a Tuesday. I don't want to do it on a Thursday evening, but I thought if we can get committee approval, fit in 1 hour, we'll leave it up to the clerk to deal with, set a time with Stellantis for 1 hour on a Tuesday. Or we can just adopt the motion as such. I'm sorry, go ahead.
Je pense que vous pourrez...
I think that you can see that we all agree that Stellantis' representatives all must come here. Here's my question. Do we ask them to appear in person? So if they know ahead of time, they can travel here. But I also wanted to table a motion, and I think my conservative colleague as well. But the final result is the most important, and I support this motion.
Sorry, reading the last part, it's by December 9th or on December 9th?
On December 9th.
Okay.
I'll read the motion again for
yeah,
colleagues.
If you don't mind while I'm checking our calendar.
That representatives from Stellantis, Inc. appear before the committee for at least 1 hour to discuss the motion for the production of papers adopted on Monday, October 20, 2025, about contracts with Stellantis, and if they do not appear on or before December 4th, that a summons be issued for them to testify before this committee for at least 1 hour on December 9th.
Thanks. Just December 9th is tentatively or close to what we have for the PSPC minister for the SUPs. So if we do go ahead, perhaps again, that's something we make it a perhaps a bit longer meeting on a Tuesday. So we'll start a bit earlier or we'll move a bit later. But hopefully it won't require a summons to have them here by that time. But just FYI, but I think we all seem in agreement. I see nods all around that we can accept that. Wonderful. So moved. If you leave it, oh, Madame?
While we're on the topic, I just want to ask how many meetings are left? I also think about the Canada Post study. We know that union and management came to an agreement on Friday. So I expect the CEO appear here as soon as possible. Of course, before the Christmas break, so he can answer our questions. And on the Kaplan report, I just want to know, what about that when it comes to our planning? Because 4 million addresses are affected. And 17 million across Canada.
For the President of Canada post. The Kaplan report has not been given to us, but I'm going to suggest perhaps we ask for it. When we went through this previously in 2016, when I was around for the first Canada Post, there was a task force arranged by the minister at the time, Minister Foote, and it was called the Canada Post in Digital Age. That was actually shared with committee as part of our study. So perhaps we can ask that we get the Kaplan report released just before December 4th. And then we didn't have any other meetings on that. I think the general agreement, I think, was we'll see what the president has to say now that the strike's been settled. And then we'll kind of go from there, see what the report says. And then Minister Lightbound will be here hopefully on the 9th. We can do a quick follow-up, and then we can decide in the new year if there's any other meetings that need to be followed up on. Madam?
Sorry, Chair, I just wanted to make sure. I know that we can't compel witnesses to appear in person. Yeah, however, I do think that it is our role, as we reach out to them, to encourage them to come in person so that they don't deal with technical issues at the last minute.
I think we'll make a very, very strong recommendation, and I'm sure you're right that they were watching our Power View and they've heard our concerns, but we'll make that a very strong recommendation. We're pretty much done. I just have to do budget approval quickly first. Before we do so, witnesses, thanks for being with us today. I will note we have gone through this procedure with the vaccine contracts where we did very similar, where we had Pfizer and the other manufacturers come in with PSPC and public accounts. And the fully unredacted ones were given to the committee for review under the rules of no phones, no notes to be taken out. So there is precedence for fully unredacted contracts being shared with Parliament. We will excuse you. Thank you for joining us. We appreciate your time. And just very quickly, we've got $1,750 for this study. Mm-hmm. If we can just have quick approval. Again, we won't spend that much, but wonderful. We'll get back to everyone as soon as possible regarding possible dates for Stellantis. We should probably maybe think among ourselves. We can discuss it on Thursday if we will have any from industry back at that same meeting. But perhaps you can talk among yourselves, and we can decide for briefly on Thursday. Yeah. We'll do that. If nothing else, thank you for all those who subbed in today with some great questions. Certainly appreciate it, and we are adjourned.